Okay, so bankruptcy, restructuring, and transactions. We're just going to dive into it here. We're going to talk primarily the differences between a 7, 11, and 13. How much of this is going to actually be on your real estate test? Not a lot. But knowing the 7, 11, 13, little things about bankruptcy, it's the little things that if a question comes up and talks about bankruptcy, know the primary basics of what it is. Identify the parties to the bankruptcy proceeding, discuss the order of events that happen. We're going to talk about the importance of a proof of claim. We're going to talk about what occurs in single asset real estate bankruptcy, and then we're going to explain the rights of landlords and tenants within a bankruptcy. And unfortunately, as a landlord, in the last couple of years in the retail environment, I've been dealing with several tenants that have filed bankruptcy. And it's always interesting. We have good legal counsel, and I just kind of sit back and I watch. But the owner is taking a risk. It's a big risk that they're never going to be settled, and they're never going to see their funds. And it happens. And that's part of the risk of owning real estate and being a landlord. Purpose of the bankruptcy. It's providing a method by which to resolve the conflict between creditor rights and the relief that debtors seek in filing for discharge in the bankruptcy court. So in America, we have this thing where we can actually file bankruptcy. We can be relieved of our debts. It impacts our credit score for 5 to 7 years, and then we can go on with life and start over again. We take that very much for granted in America. In other countries, if you file bankruptcy, it affects your second, third generation of people. It affects your entire family because your entire family is trying to pay off this bankruptcy. So people very much commit suicide and stuff like that because they're ashamed. In America, it's not the same anymore. Hell, if our damn president can file bankruptcy on his firms, why can't we, even our president has filed bankruptcy in some of the things he's done. He survived just fine. And we elected the guy. So bankruptcy doesn't have the same kind of stigma in the United States it does in other countries. So the parties in our bankruptcy, we have the U.S. bankruptcy judge. We have every court, regional court has this bankruptcy is held in the U.S. courts. We have the creditors and we have the debtors. The creditors are the people that we owe money to. The debtor would be your client or the homeowner. The matters that are relevant, they're going to want to focus on the debtor's financial affairs. What has the debtor been doing? What has happened with their education? How much have they been trying to stay current with their bills? Have they lost a job? Have they had medical issues? Have they gone through a divorce? Divorce is a primary reason for bankruptcy because you have dual incomes. All of a sudden, you got to split assets, and spouses always can't function without having that other income that they were counting on for a long time. So all these things are going into what is going on with the debtor. So the court proceedings involve issues directly affecting the debtor's reorganization or discharge. How can the debtor reorganize? Most personal bankruptcies, the debtor's not reorganizing. The debtor is going to ask for discharge. They want to have the debt relieved and they're going to walk away. So who pays for that debt when that debt's relieved? Everybody, the citizens. We all pay for it for taking credit, for borrowing, for everything we do. But in commercial applications, the debtor's reorganization or discharge, okay, I managed 2 properties of mattress firms. Mattress firm filed major bankruptcy. They had lots of locations across the U.S. We found out that they filed that bankruptcy, it hasn't even been 2 months. They've already discharged the bankruptcy. They're done. And what's happened is they were able to use this to be able to go to the courts and to some of their landlords and say, we're going to shut these stores down. We have too many stores in the neighborhood. It's not profitable. And as the landlord of mattress firms, we're still saying, what are they doing to make money? Because we don't see people in stores much, but they're making a ton of money. They make about $1,000 a square foot for their stores. And we're still trying to figure out what are they doing to make that money. So they've already come out of the bankruptcy. They've discharged or said, these are the leases we don't want anymore. Landlord, you're stuck with them. We're done. Anything that's owed is owed on them. The lease is still doing. Landlord, you're on your own. You get to do this. Meanwhile, we have 2 locations, and supposedly they're actually going to keep the locations. We just now have to redo their leases. They've asked for reductions in rent. but they still want to basically keep their stores open. For us, as a landlord, it makes more sense to work with them because we don't have another tenant knocking on the door trying to take their space over. If we had other tenants trying to take their space over, we'd reject the lease. But as a landlord right now, we're saying, we'll let them negotiate. We'll work with them. They still owe some charges. We're going to get them current on the charges they owe and all those kind of things. But, so that's a bankruptcy that happened in a matter of like 2.5 months. Declared it, did it, and done. Residential, the regular bankruptcy procedure, it can take 6 months to a year to go through the process to file your paperwork. And then, like I said, it'll impact your credit for 5 to 7 years. But it's not the end of the world. Bankruptcy is not losing your life. Bankruptcy is just a financial mess. And people don't always step in that financial mess on their own. They're led to it for many reasons. Okay, so the court proceedings, issues directly affecting debtor's reorganization or discharge, what is their ability to be able to pay the debt back? Where is that money coming from? Are they in line to inherit money 6 months from now? Is something going to happen with their job or their position to really change the financial picture? Or could they lose their job and become even worse? Where's it going? NonCore proceedings. A legal proceeding is not essential to the disposition of the bankruptcy estate. So we have core or non-core provisions. The Chapter 7 is a bankruptcy petition, also known as liquidation. Provides the debtor with a fresh start in exchange for distributing all the debtor's non-exempt assets to the bankruptcy trustee for liquidation. Again, when you are small residential and you're going to a bankruptcy, you're going to have almost no net worth. You've gone through everything. You've already paid down all the loans you can. You've already made as much arrangements as you can. And you're at a point where you just don't have much net worth. You can't even own a real expensive car because they're going to look at all these assets and say, can we sell them? Can we do something with them? Now, they know you have to have a car. You need to drive to be able to get a job and keep a job. But you don't have to have the Lexus or the BMW. You can have a Chevy. You know, it's just what it is. So Chapter 7 is liquidation. We're going to liquidate. We're going to be done. And we're going to, whatever debts are out there are going to be discharged, and we're going to go on. And the debtors are going to be responsible for the discharge. It's on their laps. Chapter 11, reorg, is petition allows a distressed business such as a partnership or corporation involved in operating real estate to restructure their finances. So that's more than likely what happened with my mattress firm. They went through Chapter 11. Elder Bierman, who was part of Bon-Ton stores, Toys R Us, they all went through 7s. They're done, they're gone, except they had a little bit left. Toys R Us, guess what? Have you guys remember reading anybody who bought part of Toys R Us assets? Kroger. Kroger bought part of Toys R Us assets. You're going to start seeing a lot of toys in the grocery store. Not what you expect to see them, but if you go to the Oakley store, you'll see a whole section now toys rather than clothes and some other things. They're going to take a store section devoted to toys. Elder Bierman Bon-Ton Stores is the parent company. Bon-Ton's still out there with their trade name. They're actually trying to start opening stores again. They've been through the bankruptcy close. So what happened? We lost an Elder Bierman store up in Dayton, 101,000 square feet. It was a third of the center. $36,000 a month rent coming in. They were on a lease for another 2 years. They paid a third of the real estate taxes of owning the center as part of their CAM charges. So we, as a landlord, we lost all that income. Fortunately, we found another tenant to come in and take their space. Otherwise, that space could sit vacant for a long time. Could sit vacant for years. But we were able to find another tenant to come in. We're going to be a year without that rent. But we have another tenant that actually started reconstruction Monday. And they'll open by March. It's called At Home. And they'll pay us rent. We're going to be out of rent for the 6 months Bon-Ton was closed or out of rent, reconstruction. And to lure this new tenant, we're giving them 6 months of free rent too, to offset all of their capital improvement costs. They're demoing the entire interior of the building. The roof and the structure walls are staying, but the total interior of the building is being demoed, and they're rebuilding it. So part of the landlord deal is to do that. Did we get anything from Bon-Ton, the parent company, for doing that? No. Bon-Ton just walked away. So the landlord absorbed all of the losses for that. What else did Elder Bierman leave? They owed a lot of creditors for the merchandise that they were carrying. And all the employees that were working for them. don't know if they had retirement accounts or what happened to all those kind of things. Supposedly we have safe harbor retirement accounts now, but some of that stuff is still impacted by this. So again, it just depends upon what it is. Those were 7s. 11 is reorg, that's mattress firm. 13 is a bankruptcy petition provides for an adjustment of an individual's debts. So they basically say, I'm still solvent, I still have money, but I need to be 13. I can still pay some people back, but not totally, or I can pay them back on extended terms. So 13 is something we can see individuals go through, we can see businesses go through as well. Bankruptcy trustees, the legal representative of the bankrupt estate. Broad powers are granted to this person. They actually go to the court hearings. The U.S. trustee is the government employee appointed by the Justice Department to perform administrative tasks for the benefit of the bankruptcy courts. So if you go into bankruptcy court, you see these people all there in the court session. And their attorneys, that's all they deal with is bankruptcy. That's their specialty, because it's such a big part of the legal business. We have something called a debtor in possession. The debtor continues in possession of its property. They enjoy the same rights and powers as well as the obligations of the trustee in the bankruptcy. We have a creditor, the entity that can claim against the debtor. We have a creditors committee. It's appointed by the U.S. trustee in 11 cases, responsible for representing the interests of the unsecured creditors. So if there's an 11 type organization going on, unsecured creditors, they're trying to get them their money, get as many people paid as possible, and negotiate it possibly the best way they can to get that payment done. So the procedures happen. We have, if you're individual, you're going to go through bankruptcy counseling and education. You have to file the bankruptcy petition. You have a creation of a bankruptcy estate, which is basically what are all your assets, what are all your debts, meeting of the creditors. As an individual, you would never know that happened. They're doing it all through attorneys. An automatic stay of most civil actions against the debtor to stop things from happening. Creditors file proof of claim. They have this window of time. Notify all the creditors, legal notices. You have to file proof of claim. If there's money left, you can stand in line to try to get it. The debtor may execute reaffirmation agreements, so they might let you reaffirm the debt so you can reestablish the debt. But that might be a longer payout period. It might be a higher interest. There's all kinds of things that can happen as a reaffirmation of the debt. They'll distribute the property. They can discharge the debts, and then finally they close the bankruptcy estate. So they close the estate again, like I said, after 5 to 7 years, the person just walks away. They're done. It impacted credit. It can impact jobs. It can do all kinds of different things because it'll stay on the credit report for a period of time. But it's not life and death. It's not the end of the world. We have bankruptcy counseling education. They have to receive counseling by a approved counseling agency within 180 days. This is online type stuff that they do. They don't actually have to go to a class. It's mostly online stuff. They file a bankruptcy petition. They can do a voluntary or involuntary. Most people it's involuntary. They don't have a choice. They didn't try to decide to do this. Other times it's voluntary because it's the quickest, easiest way to get through it. And then they create the bankruptcy estate. Again, it encompasses all legal equitable interests, creates an order of relief. And then there's property that's exempt from the bankrupt estate. They may keep certain property from the bankrupt estate. 401, retirement funds, things like that are not part of a bankrupt estate unless you cash them in prior. They are exempted. But the house, like I said, the house is on its own. It has secured creditors. So it typically is not part of the bankrupt estate. Student loans. You don't get rid of student loans with bankruptcy. There are certain types of obligations like that. No matter what happens, you won't get rid of them. You can have a stay where you don't have to make payments on them, but you don't get rid of them. Creditors meet. Then there's a stay against the debtor. Provides a period of time in which collection activities, foreclosures, repossessions of debtor's property are suspended. The creditors may not pursue the debtor or debtor's property for any debt or claim. And then the creditors, again, file proof of claim. Anytime you do a lien, as somebody that's the lien person, you're going to file proof of claim. The debtors are going through the same thing. There's a secured claim, secured by a valid lien on the debtor's real or personal property. Okay, so what kind of things do you have that are secured? It's secure property. What things do you take loans out that are secure type property?
Mortgage.
Mortgage?
Cars.
Cars. Middle night repossession. You know, only this thing with the car thing, you may have already been through the middle night possession, but if you're not, they're going to say, wait a minute, there's a lien on this if there's a loan on it, or there's certain value on it, they'll force you to sell it. Unsecured claim, no property asset serves as collateral or secure for the debt. That would be charge cards. For the most part, they're unsecured creditors. Debtor can execute reaffirmation agreements in which the debtor agrees to continue to pay the discharge. Or the non-exempt property must be distributed to debtor's secured and unsecured creditors. Again, Chapter 7. Usually after Chapter 7, again, personal type things, there's not a lot left. It's pretty much done. You have the discharge. You have the revocation of the bankruptcy discharge can be revoked under certain circumstances. If they find that what you did was you lied about a lot of stuff or things were fraudulent that you were doing, they could revoke the bankruptcy. It's not going to help get anything settled, but you may end up going to jail instead. Closing bankruptcy estate, then it gets closed and it's done. Not real severe, it's just kind of what it is. So here's what the real piece of this whole thing is, the real property bankruptcy issues. Short sales. When the seller's mortgage lender agrees to accept less than what's owed on the note in exchange for releasing the seller borrower in order to facilitate a sale. So this is something you'll run into in the real estate world a lot, is short sales. We were going through lots of short sales in 9 and 10. We're not seeing them as much anymore, but still people run in circumstances where they do them. Realtors, I've met realtors that specialize in short sales. I've met realtors that have told me they will never ever take a short sale. Because when the short sale is happening, the bank can basically take 6 months to get through the paperwork. While they're doing their paperwork to get all the stuff through the bank to get it cleared and everything, they're open to taking additional bids. So if somebody bids higher, you can lose the property because somebody else bid a couple dollars higher, literally lose the property. Because it takes 6 months, you get pre-qualified for a loan, you got to go back through that whole process again. When you hear from the bank you're finally able to get the asset, you got to go back through the whole loan qualification piece because they won't pre-qualify you and keep you open for 6 months. They'll keep you open for about 30 to 90 days, but they won't keep you open for 6 months. So you end up having to go through the whole loan process again. And again, like I said, a lot of the reason the realtors that I know of that don't like them is because the fact that the banks are basically continuing to take bids, and people don't realize they're not successful until all of a sudden last minute they hear, oh, by the way, you're not buying it, somebody else is. And people have got their hearts and souls in the fact that they think they're going to get these properties, and then they don't. So it's a letdown for everybody. And then the bank doesn't want to pay full realtor fees. But the idea behind a short sale is if I go to the bank and I tell a bank I want to do a short sale, it's not going to negatively impact my credit like a foreclosure is. That's the whole idea. That's the reason we want to do it. But what happens when you have a short sale is typically it's selling for less than what the mortgage is. So you've got a mortgage and then you've got the sale price. There's a gap. There's two things that can be done with that gap. The bank can come to you and say, by the way, we're coming after you for the difference. Or they can say, we'll waive the difference, but by the way, here's a 1099. You just made another $20,000 worth of income that you didn't realize you made this year. And now you owe 30% taxes on that because you got 1099. So it's not always, it's more positive than going through the foreclosure and things like that, but it still may end up, the financial ends of it is not as pretty. You really have to think about it. If you get involved in short sales, there are specialists in your office that have been through it before. If you're in a large real estate office, what you want to do is tag along with these people. Get some advice from these people. Get them to counsel you through this whole process. Maybe even pay them some of a fee to help you take people through this process, to go through it, as the buyer or seller.
So if you're doing a bunch of short sales, you'd have to have a lot of money out
Do you still have to put a down payment on it somehow, or
Yeah.
hold it?
Yeah, you're still going to put a down payment, but it's not a huge down payment. It's like escrow money.
Right.
Yeah. And you'll get it back if you're not the successful bidder. It's not a whole loss, but it's just that you're tied up for 6 months. What's going to happen? Yeah, what's going to happen in the 6 month period. So there's also something called lien stripping. In certain cases, the amount of secured claim may be reduced or stripped down to the fair market value of the collateral as the petition date. That's something you're going to want to have an attorney help you out with, is this thing called a lien stripping. There, like I said, there's plenty of bankruptcy attorneys. It's a whole line of legal practice that can help you or a client through this process if they have to go through it. So as a good realtor, you're going to understand short sales. You're going to get somebody to coach you with it. You're going to have a good list of bankruptcy attorneys to help people go through the process.
So that lien stripping, that's almost like depreciation.
You're stripping it down to fair market value. So you're saying, yeah, it's a depreciation measure. I haven't seen it happen, but the short sales I've heard of. Single asset real estate cases prevents debtors with no hope of rehabilitation from frustrating the lender's foreclosure actions. Again, the single asset, they're going to take foreclosure on it. I had a student years ago that sat in my class, and his whole job was to go to people and give them a couple $1,000s to get them out of the house. I'm like, God, that has to suck. You know, that's a really depressing job. You're walking up these people that are going through, they're getting ready to be foreclosed on, and you're coming to them and you're saying, here, I'm going to give you a couple $1,000 because I want you to get it out of the way. I mean, people would shoot you almost, come up to the door. But I said, how do you live with this? What are you doing? He said, because I'm a help for those people. I'm a couple $1,000s that they wouldn't have had otherwise. I'm literally a way to get them whatever possessions they have packed up, moved, and taken out of the house. So he tries to keep a positive spin on it when he approaches people. And it helped the people trying to get the houses back because they didn't end up with destroyed houses. They ended up with a relatively broom clean house after he would go through. That was the agreement. I'll give you a couple $1,000, but you're going to get the house broom clean rather than having a house destroyed or left full of crap. Because a house left full of stuff is almost as expensive. My Elder Beerman store was left with about $40,000 worth of fixtures. Literally, it would cost us $40,000 to pay a company to haul them away. So we left them in there. So I was joking with a contractor the other day. How many of the construction workers took tables and stuff home? Lots of them did. Because they're good quality, heavy-duty stuff to be in a store to use merchandise. But they're still going to fill up a ton of dumpsters. But they're not having to put it in a moving truck and move it away. Unfortunately, it's going to a landfill. But they've got a ton of dumpsters on site. And his goal literally was, they started Monday, they wanted to have the store stripped out and cleaned by this Friday. Literally, everything, all the fixtures packed up, the ceilings ripped down, everything. I don't think that, he said that he's not quite on that schedule. I won't go up there for a couple weeks. By the time I get up there again to look at it, it should be totally wiped out. I should just see walls. So the single asset, that's what they're going through. Sale of real property free and clear liens. The debtor in possession or bankruptcy trustee has the power, subject to court approval, to sell the real estate property free and clear of all liens. So you're getting, if you go to the foreclosure sale, you're getting a property free and clear of all liens. Because the foreclosure stripped everything out. You're going to get a new deed, you still want to go through a title search. You still want to get title insurance to protect your asset as the buyer. You're going to the foreclosure sale on the county's steps or whatever to buy it. But after the fact, it's always a good thing to go ahead and get title insurance. It's a few $100s for the thousands of dollars you're going to spend to protect you. Because even through foreclosure, you're getting a clean, quote, sale or sheriff's certificate. You still want to have that title insurance. Abandonment. When the continuation of property is so burdensome to the estate that is not beneficial, a lot of these houses get abandoned. And at that point in time, the bank doesn't want to deal with it. The county has it. And eventually it comes to a tax foreclosure because the houses literally sit for years. People don't pay on them. You can go through Detroit and you can see this up and down streets where people literally just walked away, quit paying on it, quit taking care of it. The city took it back. County took it back, and then they're selling it for literally a few dollars to get somebody just to come in and buy them. Bad faith filings may compel dismissal of any, again, if there's something going on that's fraudulent, it's not in good faith, they're going to dismiss this whole bankruptcy piece. Avoiding transfers allows creditors to receive more than they would have otherwise received in a Chapter 7 liquidation if they have preferential transfers. If there's fraudulent transfers, again, the whole thing of bankruptcy is done. Allows the trustee to avoid the fraudulent transfer if it's made within 2 years of the filing of the bankruptcy. So, residential and commercial leases. The landlord is allowed to offset delinquency with a security deposit only to address pre-petition claims for unpaid rent. So if my big tenants would have had any security deposit and I had unpaid rent as a result of security deposits, we could go ahead and use security deposits as applied against the unpaid rent. Most of my commercial leases don't have security deposits, by the way. We just don't do it a lot. We only do it with real small people we don't know of, but for the most part, these big companies aren't paying security deposits. Commercial leases. Bankruptcy court will examine the substance of the agreement between, determine whether the rents are collateral of the creditor or includes the property of the bankruptcy estate. And then the expired commercial leases, the bankruptcy code allows the landlord to recover possession without seeking relief of stay. So what happened when Elder Bierman filed bankruptcy? They met with me one day, the store manager, on August 31st. They said, here's your keys. We're done. We're not paying any more rent. We're done, period. Here's your keys. Was it peaceful and quiet? Sure. We took it all back, and we didn't have to go through another whole court proceeding, through an eviction process or anything like that. We just took it back. Sears is going through bankruptcy right now. I'll go up to Dayton December 12th to the Dayton Mall, and I'll do an inspection on that store for the company I work for. We manage some of these Seritage-owned property assets. And I'll do a walkthrough and get the store back from the liquidator and from a district regional manager at those facilities. They'll do the walkthrough with me, and we'll lock it up, and then we'll be done. But I want to make sure the cooling tower is drained. I want to make sure that the asset is preserved and encased and bombed as well as it can be to mothball the building while they decide what to do with it. I still go up to Kenton, Ohio, which is north of Bellefontaine, Ohio. Every couple months I go up and inspect a vacant Kmart building. Same kind of thing. They moved out, they turned over the keys to us one day, and it's just sitting there vacant. Now it's been a year and a half. It's been sitting vacant because they don't have a user to come in yet. It actually has, there's a bar on the side of the driveway for the people to put their horse and wagons because it's Amish community. They actually have a hitch. And I took a picture of it because there's a hitch on the property. Never seen a hitch before, where you can tie your horses up. I'm always a little nervous when I go to the building because it's vacant. Have my cell phone on ready, have a good flashlight with me. People know that I'm going to the building, my staff, and I don't call the police. Alarms don't work real good in the building. There is a burglar alarm. But it's one of those things, the asset is just sitting there waiting to be redeveloped. And they didn't get anything out of the... Seritage bought all of these buildings knowing that Kmart and Sears eventually was going to close down with the idea that they could redevelop them. I just started managing 2 buildings in Chicago that are Toys R Us, former Toys R Us buildings. Same kind of thing. They bought them out of bankruptcy. One's a Toys R Us building that's all by itself. Another one is actually, it's a small strip center. And Toys R Us has neglected the hell out of the tenants the last couple of years. When they had snow removal done, they always cleared the Toys R Us lot, but they didn't clear the rest of the lot. Now we're doing just the opposite. We're clearing things for the people, but the Toys R Us lot, we're going to pile the snow on it. But it's just, again, the idea was to buy them to think of the redevelopment potential, because Toys R Us has pretty good locations. So it's that real estate location thing. That's why they're trying to get them. And they got them for pennies on the dollar. But they're not inexpensive assets to own. Just to own a building for a couple months is over $30,000 because you got to pay taxes and utilities and maintenance. Acceptance or rejection of the leases. Chapter 7, cases of all residential lease, the trustee may decide within 60 days after the order of relief or date set by court to either perform or lease obligations or reject them. Chapter 11 or 13, the trustee or debtor in possession generally may allow the parties to assume or reject the lease. Again, so as a landlord, this is what we're working with the tenants. If they can come out of bankruptcy, we'll assume the lease, we'll keep them in place, or they reject them and walk away. Creditor, however, may file a motion of court order fixing the time within which trustee or debtor in possession must decide whether to assume or reject the lease. We haven't done that because these things have been going through pretty quick. An eviction. Oh, H.H. Gregg is another tenant that filed bankruptcy. We lost them, and the store sat vacant for a couple months. Again, we were fortunate. We found another tenant, and the Aldi grocery store came in and took it. And I drove up. I turned the keys over to Aldi. I drove up a month later. Unfortunately, somebody told me what happened. Literally, the whole front of the building was gone. They blew it apart, totally rebuilt the building. And I pulled up. Fortunately, I was told by the next door tenant that the building is not the same at all anymore, Joyce, because I would have had a heart attack not knowing, being prepared for that. But that's, again, that tenant, Aldi paid for all that tenant finish to reconstruct the building to make it an Aldi grocery store. To go from an H.H. Gregg furniture showroom to a grocery store was quite an adventure. They spent a lot of money doing it. Eviction. Residential tenants filing bankruptcy must disclose in their petitions whether the judgment for possession of their residence has been entered. Okay, so you can evict, but you're going to stop. The eviction is not going to work. Tenants are protected from evictions through this whole process. Eventually, you'll be able to get rid of them, but you might not collect rent for a couple months. Strategies, again, terminate the lease under state law and obtain possession of lease premises before the bankruptcy is filed. Good luck. Obtain a guarantee. File an action based upon the endangerment of the property for illegal use of controlled substances. Okay, there you go. What were they doing in the property? What led to all this? Again, this character of the person in the property, we're exploring who they are and what they did. Were they doing anything illegal? Can you kick them out? Can you get a sheriff to come in before they ever even get that far in life? And then you obtain a judgment for possession. And that's what happens with bankruptcies. Any questions? It's not pretty.